The broadcast is now starting. All attendees are in listen-only mode.
Good morning to those of you in Europe and good afternoon to those of you who are listening in from China. This is Anne-Laure Maddy, Communications Manager at the EU SME Centre, and you have joined our webinar series, How to Manage Contract Terms and Minimize Risk in China. Welcome. Before we get started today, I would first of all like to wish you all a very happy new year. This is the first webinar that we are having in 2013, so happy new year to all. And just before I introduce to you our speaker for today, I would just like to remind you of a few little housekeeping rules. So first of all, to see how many of you have joined us today, you'll see in your control panel on your desktop a hand icon. If you could all raise your hands, and then we will see how many of you have joined today. So if you could all raise your hands, first of all, to see how many of you have joined us today. You will see the hand icon in your control panel. So I can see many of you raising your hands now. Okay, that's great. And I remind you as well that throughout the course of today's webinar, you can ask us any questions. If you're experiencing any technical difficulties, you can also type those in the box indicated on the screen. We will try our best to answer all questions that you may have today. But if ever we don't get to everybody, because I can see there's a large audience today, I would encourage you to visit our website at the end, and through our Ask the Expert channel on our homepage you can post your question, and that will go directly to our team here at the centre. Right, so I can see that today we've got a few new people joining us as well as some returnees, so welcome to all of you. I'll just take literally a couple of minutes to refresh those of you that know us already, but also to introduce the Centre to newcomers. The EU SME Centre is a project that is funded by the European Union, and it is a business centre established here in Beijing to provide very practical business support. The Centre provides very practical business support to European small and medium enterprises looking to invest and export in the Chinese market. The information and advice that we provide is free of charge, and we're an office here in Beijing of 15 people. We cover 4 areas of advice and information, from business development, legal issues, standards and conformity, as well as human resources. And the Centre's team is answering inquiries from businesses. You can post your inquiries to us through our Ask the Expert button on our website, as mentioned before, and you can see the link to our website below on your screen. Now, aside from answering business inquiries, the Centre is also producing a range of market studies, reports, guidelines and case studies, and you can find these in the knowledge section of our website, the Knowledge Centre. We also provide trainings, seminars and of course webinars such as today's, and you can find all upcoming events from the calendar on our website online. And just for some latest news from the centre, we have now launched the first part of a new diagnostic kit. Are you ready for China? And the diagnostic kit is a 5-part business support tool comprising of 4 reports and an e-learning module. And here's what you see on the screen now is an online quiz for you to check how prepared your company is to take on the Chinese market. So I encourage you all to follow the link below and to have a little look at this online questionnaire after today's webinar. But without further ado, to the topic at hand, and today, as I mentioned, we're looking at managing contract terms and minimizing risk in China. So I would like to pass the floor to our in-house legal expert, Ms. Ludmila Hiklova, who will give the webinar for today. Ludmila, the floor is yours.
Thank you, Anne-Laure. Hello, everybody who is joining our today's webinar, and I hope that we will bring you some useful information for your business. As Anne-Laure introduced the Centre, one of the tasks of the Centre is to help European companies, small and medium-sized companies, to export to China. And this webinar is in line with this task, and we will focus on one of such contracts, which is exporting goods, especially goods to China. So what we will do in today's seminar, in the first part we will focus on recommendation and we will try to recommend you some activities, some actions which you should do even before you start negotiation with your business partner. In the second part we will focus on contract, which will be sales and purchase contract between the the sales and purchase contract between European seller and a Chinese buyer. So it will be contract from the point of view of the European seller. We will focus on the provisions which you shall always include in your contract, which you shall never omit, and we will give you some general tips for concluding a fair contract. Sales and purchase contract is not a difficult one. However, and very probably this is the reason why there are so many difficulties with this contract, because many people think they can draft it themselves without legal help, or they simply rely on the templates or the templates received from the country party. But before we go directly into the topic of today's seminar, we would like to understand what is exactly our audience, so we can target better our presentation. So I would like to ask Anne-Laure to help me to set the first poll. And the question of the first poll is, what is your experience with exporting to China? And you can see the options if you have concluded no contract yet, or you are just in the process of negotiation, or you are already experienced with contracting with Chinese partner. We will give you a few more seconds.
Right, so I can see that you're all putting in your polls. I will close the poll now. I think everybody has, most of you have answered, so we can see the results. And I think it's very interesting, actually, Ludmila. I think today's webinar will be very useful to all those taking part. So over half. So over half of you have not yet concluded any contracts. So I think this webinar today is very timely, in fact. So Ludmila, I pass the floor back to you, and I let you carry on.
Excellent. So let's start directly with the first topic. And the first topic is, as I mentioned, it's recommendations. So even before you start thinking that you will export some of your product to the China, you should make a market research. That there is a market, that there is a niche, there is options for your product. You should verify, if you find out that there is a place for your product in the market, you should verify to which category your product belongs to. Chinese government has issued 3 types of the catalogs according to the type of the goods. You can have prohibited, restricted, or the goods for the free import. So you shall check all these catalogs and identify where your product belongs to. If you find this one, then what should follow is if you need some certifications or licenses. And nonetheless, you should be sure that the person you are dealing with or you will be dealing with is the company who has import-export license. Basically, that this company is authorized to bring your product to the Chinese market. With all those items, the center can help. We have a guidelines which you can find on our website, or you can simply send us an inquiry. So now when you are sure that your product is allowed, you know what standards it has to comply with, there are the questions about your partner. Because in what partner you select, that will be the quality of your relationship. What you shall consider when you meet your partner is the way how you have met him. Was he recommended by someone? Is the person who is recommended a trustful one? Have you met him in some international affair? So when you evaluate this topic, then you shall go and ask directly for the business license. I will touch the business license a little bit later on, but you will find a lot of information how to verify your Chinese business partner in the report which we have published recently, and the report is the name of the report is Knowing Your Partners in China. And you can download it. Those who are registered in our websites, you can download it directly on the link which is at the end of the slide. Now you know your partner, but then you shall know something more. You shall assess your bargaining position. And why is that important? For example, it will give you the opportunity to introduce your contract templates, which is always good because you are familiar with the contracts you are already signed in the past. To know your partner is not enough. It's always recommended you know something about the market and about the competition on the market. You shall always compare at least five offers. Then you shall consider as well if it is going to be short-term or long-term contract. Everything can influence how much attention you shall pay to the drafting of the contract. Now, when we talk a little bit about the goods, partner, and the competitors, then we will go to the contract and we will introduce or set a frame for the contract. Now, I would like to launch a second poll, if we can, and it is related to the governing law. And then the question is, what law can a foreign seller choose when selling to China? And I see that you are replying already. Maybe you are replying as well based on the slide you can see. Yeah. Okay, give you a few more seconds.
So yes, it would be interesting to find out how many of you have selected any law, the law of the seller, only Chinese, or only Chinese or Hong Kong law. So I think most of you have answered now, so I'll be closing the poll. And we can see that most of you have opted for only Chinese. Only Chinese.
Only Chinese, and then followed by any law. Basically, if you are a foreign company and you conclude a contract as a foreign company and not company invested and registered in China, you can choose any law. Only Chinese law can be used in the situation when the contract is concluded between a foreign invested company registered in China and other Chinese partner. So that's basically the answer to the poll, to the question. Now, why the governing law is important? The governing law is basically the option given to you, and when you can agree, when something goes wrong with the contract, there is a breach of law, or you cannot agree on something, which law the arbitration or litigation or the judge will use for deciding the dispute. So what are the recommended practical options? If you cannot choose any law, then of course it's better to choose your law, your national law, because you are familiar with it. You have probably some lawyers which you can use for drafting the contract and then later on for representing. The second option is a Chinese law, which will probably your counterpart insist. And honestly, there is no fear to use the Chinese law as a basis for the dispute settlement. If you cannot agree on neither option, neither your national law or the Chinese law, there are a third way, and it is UN Convention on the Contracts, which is available to all European countries with the exception of the island Malta, Portugal and UK, which are not parties to this UN Convention. Or there is a fourth option, you can choose any other law, but you shall be well familiar with it. Now, before going into the direct content of the contract, let's start surprisingly from the end with when something goes wrong. Basically, you have two options: negotiate or go for the dispute settlement. I have heard from many sides, and it's true, but not totally true, that guanxi is more important than written contract. Of course, when your relationship goes wrong, then you will have troubles. But there is not true that relationship guanxi is the only way how to do a business in China. Well-written and valid contract in your hand will help you immensely when you come to the dispute settlement. And honestly, every arbitrator or the judge will ask you what you have in your hand. Now, when we are talking about the dispute settlement and why it is important to put it into the contract, we'd like to introduce you two options which you have. First one is arbitration, which is the recommended one, and the second one is litigation, which is less recommended one. However, before you go to the dispute settlement, you should always you should calculate if it makes sense go for the legal dispute, because there are other costs involved in it. There are costs for the first like arbitration or the court fee. There are costs related to the lawyers. Then there are other administration costs related to notarization, translation, your traveling to China, and so on. So before you go for the dispute settlement option, calculate but act very, very quickly. Now these two options and advantages or disadvantages. So we mentioned that the litigation is the less recommended option. Why is that so? It is because it is less flexible and may take longer. The court in the China usually has two instances. So when you lose or win the first instance, it's very probably that either you or the other party will go for the appeal. So first, it takes time, and secondly, it does not need to be necessarily the cheapest way. If you need to go for the litigation, opt for the litigation in China. Why is that so? The reason is, there are two reasons. First one is that the most foreign court awards are not enforceable in China. And the second one, even if you win, then you shall go for the enforcement. And if defendant is a Chinese person, it is more likely that he or she will have some assets in China, not in Germany or in France. So therefore it's easier to go for the court in litigation in China. However, arbitration, it is recommended in the dispute settlement for the dispute with the foreign element, like in your case when the company is registered in foreign country. You can see on the slides what reasons are supporting this option. First, the arbitration awards are enforceable in China. You can choose arbitration placed in Hong Kong, Singapore, or any other well-known location. However, this other country has to be party to the New York Convention. Or you can choose, and very probably your Chinese counterparty will insist on Chinese arbitration. In such case, you can use the arbitration CETAC either in Beijing or in other cities. We recommend in this instance arbitration in Beijing because they have quite advanced rules for the arbitration. You can choose even the English as a language of the arbitration. However, in order you can go for this option, you have to have it written in the contract that you agreed on the arbitration body, that you agreed that the contract or disputes coming from the contract are subject to the arbitration, and it's always recommended you agree on the language, of course the place, and you can agree as well on the consistent of the arbitration tribunal. So now, when we set a frame for the contract, let's go to the content.
Thank you, Ludmila. That's actually quite an interesting way of looking at contracts starting from the end, and I'm sure that many businesses don't wish to go for the worst case scenario, but it's very important, as you mentioned, that you do think that far ahead so that you're covered from the beginning. But looking from the beginning, I guess when drafting contracts, the first thing that will come up on the first page will be the parties A, B, C, and the names that appear, and therefore of those parties. So just to start off with, to continue, sorry, with another poll. Let's see how you answer to this one. Basically, when drafting the contract, then the name of the parties, should they be in English, in Chinese, in either language, or must it be in both English and Chinese? I leave you a little moment to to answer. So it appears to be quite a simple question, and I think that many of you have answered both English and Chinese. So let's close the poll, and I'll share with you the results now. So we can see the results coming up. 58% must be both English and Chinese.
Yeah, thank you for voting in this poll. Strictly legal speaking, only those who voted for the Chinese are right, because Chinese name of the partner is the official name. It's his official name. However, it's a custom that they include in the contract both English and a Chinese name. However, the Chinese name is the decisive one, and you shall always check it, not only comparing contract with the business card you receive, but comparing contract with the business license you asked for. So the conclusion of it, the best way, of course, is to have both English and Chinese, and the Chinese has to be the same as on the business license. So we now move to the slide titled Who is Who, and it comes to the parties and the identification. As I mentioned, and it is really, really important, and we are receiving daily or weekly many inquiries related to the problems with the identification or the wrong identification of the Chinese partner who disappeared later on. So please pay careful attention to every character of your partner Chinese name. Same shall be for the address, name of the legal representative, and ask for the legal representative ID. I will not spend too much time on this part because first we had already a webinar on this topic. Second, it is covered in the report which I have already mentioned, Knowing Your Partner, so you can download it and read it. Read it at home and paying more attention to that. However, what often happens is that you are not in direct contact with the legal representative, who is the only person entitled to act on behalf of the company, but you are in the contact with the authorized, or we hope it is authorized person. In such cases, you shall always ask for written power of attorney issued by the legal representative. This power of attorney shall be attached to the contract. One question, one point which is related to the name of the partner. Don't be satisfied with the name of the partner's subsidiary or related company. For example, you are in a negotiations of the company A, you receive business license of company A, but later on, when the contracts shall be concluded, on the first page will appear as a party to the contract will appear name of company B. And you might hear reasons like, yeah, because it is our sister company and it is our custom that we will conclude the contract this way, or it is because of the tax or whatever other reason. But this one will put you to a very unsafe situation later on when you might solve some dispute. So keep in mind that the name on the contract shall be the same as name on the business license, and the same as name of the company, and the same of the company which you negotiate with. So when you ask for the business license, this is something what you will receive. This is a paper which is called, official paper which is called duplicate of the business license. It does not, duplicate does not mean it's a fake document. It means that it's a small copy of the bigger business license. As you can see, it is all in Chinese, so you would need someone to translate it for you. The best option is, of course, you ask the lawyer, Chinese lawyer, to translate it. We made translation of some sample business license, so you can see what information, what important information you can learn from it. So you see not only the name and the address, but you see as well the scope of business for that company. So, for example, when you are negotiating directly with the importer, and there is nothing written that the company has an import-export license, which will be directly and explicitly mentioned in that, then you may ask, okay, so I'm selling you the goods, but how will you import the goods to China if you don't have import-export license? And then there are other important part of the important information which you can find out on the license, like, for example, if the company passed annual inspection for the previous year. If that information is missing, then very probably the company has some troubles. Now, when we settle the information about the parties, we go to the object of the contract. If you export some valuable goods to China, where is your trademark or which is somehow protected by the IPRs, it's very important before you ship your product here that you register your trademark or any other IPR in China. We have a sister project which is called IPR SME Help Desk, and they can help you with any questions related to the protection of the IPR. They work on the same basis as we do. Basically, they are replying to the emails, and on their websites they have a lot of useful information. About the product specification, I will not spend too much time on it because everybody very probably knows the best the product you are going to ship to China. However, be as much specific as you can. What is sometimes recommended as well, if it is applicable and suitable for your product, then that you can send sample to China before the main shipment arrives, so you and your Chinese partner can compare if it is really exactly what they are asking for. As I mentioned at the beginning, you shall be interested about some certificates which your goods has to comply with. As regards the specification of the quality and the quantity, which is usually a problem when exporting any product, agree beforehand with your partner on the inspection standards and method. Agree beforehand on the independent and reputable and the trusted inspection company. Do not rely that your partner will supply you with the name of the inspection company. Have prepared one or two independent companies and include their names into the contract. Usually, because when the problems arise, it is too late and it's not easy to agree on anything later on.
Lamilla, I interrupt you for a moment, but we have a question actually on this particular slide in for certificates. When you mention certificates, the question is, can EU certificates be used in China? So our EU level certification, can that be recognized in China?
Mm-hmm. It would be the best question for our standards and conformity expert. However, I try to reply as far as I know, and I think he would confirm that EU certificates cannot be used in China. You have to apply for the Chinese certificates. Means that Republic of China regulates the standards for its market itself. So yeah, let's continue. We touch the quality and the quantity. Yes, inspection company. Now, definitions of the terminology. It is good because both parties can, not only because of the language differences, but they may have different understanding of what they are talking about. So it is always helpful in the contract have few provisions related to explanation of the terms you are using. Especially it's good measurement, weight, time. For example, if you write a day, does it mean a calendar day or is it a working day? And usually when the problems comes, each party understands, of course, its way. So agree and stipulate some and define terms which you are using in the contract. Important as well is method of the packaging. You don't want your goods to be damaged during the shipment. Now we come to the question of delivery. In your contract, you shall always specify time and place of transfer and title of the risk. You can use, and very often it's very advisable and easy to use Incoterms. However, when you use Incoterms, specify what version are you using. Basically by the year, is it 2010 or the previous, and so on. The most common terms, Incoterms, using in trade with China and other countries as well is SIF or FOB. In your contract, specify loading port, port of destination. During the term of the and the validity of the contract, you will need to exchange a lot of information with your partner. So agree beforehand on the way how you will exchange this information. Appoint and specify the contact details. Appoint a contact person and his contact details. It is always advised to have all information in written. Basically, it is evidence for the future troubles. Don't have more than one or two authorized persons. Otherwise, it may come to the miscommunication. Because it's you who are exporting the goods into the China, it is good to settle some boundaries for your responsibility. So settle some definite period for announcing of the non-conformity.
And what period would you suggest? So how long is a period for announcing non-conformity?
Usually it depends on the type of the goods you are importing, but it varies. Usually it is 1 month, 30 days to 3 months. That's the usual period of announcing non-conformity, what we can see in the contracts. We have received a question which relates to the arbitration, and the question reads: is there any precedent of CETAC passing sentence against any Chinese citizen in favor of an overseas entity? Was the sentence in force afterwards? Yeah, the answer is yes. There were such cases. I can, if the person who asked this question leave us email or some contact, we can send some examples, but definitely they are. Otherwise, the whole arbitration would not have a sense, and we would not recommend this option as a dispute settlement.
Yes, we have the logged details of the person that asked questions, so we will make sure that we send the information on.
Good. So let's move to probably the most sensitive part of the contract from the point of view of the European exporter, and it's payment. When you specify the payment conditions, be again as much specific as you can. Make clear what is included in the price. Are the VAT tax included? Is it import tariff included? Those tax and tariffs are paid by the Chinese importer, but make sure that he will not ask you to increase the price later on because he has to pay these tax. So make it clear at the beginning. Make sure which currency you are using for the payment. If you are using the foreign currency, then be aware that there are foreign exchange control exercise on the Chinese side. It may delay the payment process. So does not mean that when you don't receive the payment within 10 days or 20 days that the Chinese party does not want to pay. Basically, they have to handle a lot of paperwork and then negotiate with the bank in order the bank and the SAFE, which is a state authority for foreign exchange, approves the transfer of the foreign exchange to your account. However, you can facilitate the procedure when you insist that your party has an open account in the reputable banks. On the screen, you can see some of the big reputable banks, Chinese bank like Bank of China, ICBC, or Bank of Communication, so on. Directly into the contract, specify your bank account information and other contact details which are necessary for payments. This is part of the payment conditions. Make clear who is responsible for paying of the bank charges and other fees. Now the method of payment. Most often or very often method of payment, and must say very safe, is a letter of credit issued by reputable bank, some of them which we mentioned at the previous slide. From time to time we can see cases as well of the advance payment, like you will receive 10 or 20% of the purchase price beforehand. However, it is not easy for the Chinese party to send you this advance payment, first because they don't have any goods or any papers in the hand, and they have to persuade the bank and the state regulation commission for the foreign exchange that there is some goods or any product shipped or will be shipped into the China. So have patience with your Chinese partner. From time to time, we can see as well that you can ask your partner for the deposit, but it's not very often as well. One note to the provision: if you, for example, you are delivering often to the China, you can have a provision related to the set-off. In such case, for example, if some goods is not of good quality and you agree to set off, make sure that the notification is in written. Now back to the letter of credit or export documentary credit. On the right side of the slide, you can see the documents which are most often used to submit to the bank in order to effect the payment, and your Chinese counterparty will ask you for that. You can see there are pretty standard documents, so nothing surprising. We are slowly coming to the end of the presentation, and you can see some other points which might be useful you include into your contract. Who will be responsible for dealing with the customs? Again, the certificates mentioned. Sometimes it may happen that your contracting party will ask if they can subcontract. In such case, make sure that you are clear who is finally responsible, so you know who you can chase ultimately. Of course, insurance.
Ludmila, we have a question actually coming back to finance and bank accounts. Is it possible for a company to open a bank account in China without actually having a representation there?
Basically, it's not possible. At least we haven't seen any case like that, that a foreign company could open a bank account in China. So the answer to this question is no. It's not possible for the foreign company to open an account in China without having a representation here.
Okay, thank you.
Okay. Now, the breach of the contract, we touched it a little bit at the beginning. So what to do if there is something goes wrong. Now, on the left side, you can see some of the options you can have when something is wrong and it comes to the breach of the contract. You have to always consider what is the best for you. For example, if the party or something will happen with your goods, if it is better for you to ship or to replace the goods by the new one, or you want to cancel whole contract and ask payment of the money back. You may ask, of course, of the payment of the damages. Now, of course, at the end of the contract, there has to be sure that the contract is valid and effectively signed, effectively executed. For in order the contract is valid, it shall be affixed with the company job or special job for the contract purposes. On the slide, you can see the sample of the company job. It shall be round in the red ink with the red star in the middle. Very often we can see the contracts where the foreign party thinks they are effective, they are valid, but when you have a look at the company stamp affixed by the Chinese party, you can see it's not the real one. So basically, the contract is not valid. What is important for the company stamp is that the Chinese name, which is written inside the stamp, is the same as on the business license and the same as on the first page of the contract. You may insist as well on the signature by the legal representative, which is, as mentioned before, the person who is authorized to act on behalf of the company. In the conclusion for the validity of the contract is that unless you agree specifically in the contract that contract is valid only upon the signature, then you shall always insist that company job is affixed and then the signature of the legal representative is affixed. Yeah, and now one of the last slides. Here you can see the list of the provisions which usually nobody pays attention to, but which are important, same as the contracting parties or the subject or the object of the contract. Sometimes it may happen that you will not fit into the time into the time framework you set for the contract. So you might need to extend or renew the contract. So think about it when you are drafting the last provisions of the contract. Try to specify unusual risks in legal terms. Think about the way how you would like to terminate the contract. Give yourself some space in order things going wrong, so you can simply dissolve the contract. Sometimes, especially when you need some technical specification, you might be interested in attaching appendices and amendments to that. So directly in the contract, think about it when drafting the contract, that some specification shall be deemed as a part of it as well. Sometimes it may happen then before conclusion of the contract, you had some sometimes it may happen that you had already previous communication of some contracts before signing the new contract. So make sure that in the new contract you clarify what is the relationship between the current contract and the previous one. Confidentiality clause shall be standard part of it as well. And of course the language. It is good to agree, of course, on the English version is prevailing. However, your Chinese counterparty will probably insist that the Chinese language is the decisive one. So in such situation, make sure that the contract is translated by a lawyer. So in all cases, English and Chinese version is identical. So now we are coming to the end of the presentation, and our recommendation is take your time. We have seen cases where the party was forced. You have to reply to us by Friday 1 o'clock. Otherwise, we will not conclude a contract with you. That's not the responsible way how to negotiate, and you shall never be forced into such deadlines. So take your time. Contract. Every contract is always a result of our teamwork. So it's not only for the lawyers or the management to conclude a contract, but it should be cooperation among other part of your team, like finance, businesses, and other professionals. If you are concluding the contract with the Chinese counterparty and you choose Chinese law as a ruling law, then it is advised to seek Chinese law expertise. It does not need to be necessarily the expensive one. There are a lot of Chinese lawyers who has very does not have expensive services, so you can easily afford it.
Okay, thank you, Ludmilla. Actually, on that final note, where, as you say, it's very important to seek extra legal advice. We do, in fact, have a service providers database on our website, which will give a listing of lawyers, law firms, and as well as other specialized service providers. So I can encourage you to have a look on the website for any further information, therefore. Now we have literally just a couple of minutes left, and I can see that there's quite a lot of questions that have come through already, so we may not be able to tackle each and every one, but I repeat what I said from the beginning. If we don't manage to answer your question, please do take a moment to visit our homepage, eusmecenter.org.cn, and post your question through the Ask the Expert button, which you can do so upon registration. Ludmilla, I have a question here about on the financial side. So can a Chinese bank be asked to provide a letter that the company in question, so in this case it's the Chinese business partner, can the Chinese bank provide a letter to confirm that that business partner has a bank account, confirming that their company has not had any issues with payments in the past?
Yeah, the Chinese bank of your partner can provide such letter. However, it cannot be you who will ask that question. It has to be the partner itself.
Okay, I see another question here. Is the contract invalid if it does not have a stamp with a chop?
It does not need to be necessarily invalid. It depends what you say directly in the contract when contract is valid. If you say that the contract will be valid when it's signed by legal representative of both companies, then it's valid. However, in China there is a habit, there is a custom that you shall affix the company stamp, and it's safer for you.
I think that we're actually running out of time now, so I'm afraid we're only managing to get to your questions. Maybe chance for one last quick question, Ludmilla. I can see here a question on taxes and fees for imports of goods. Mm-hmm. What taxes and fees are applicable on goods for import?
When you are importing the goods, usually the VAT import tax is applicable in some type of the goods, like luxury good, as well the consumption tax is applicable, and of course there are the tariffs. I mean import tariff.
Okay, thank you. So apologies to those of you whom we haven't been able to answer. But today we will have to finish now. Just before we go, thank you first of all to Ludmilla for this very useful, very insightful webinar today. To all of you listening, thank you for your patience. I encourage you to fill out the very quick survey once the webinar is closed. And just to inform you that the next webinar that we will be putting on will be on the machinery sector in China, and that will be on the 29th of January. We have many, many more webinars coming up over the coming weeks and months, and you will find out about these in our monthly newsletter, as well as on our online events calendar and on our social media. So thank you to all listening in today, and we look forward to hearing and seeing you in our next webinar. Thank you very much.